first question we've got, Chris, it's directed to yourself, but Cleve, you're more than welcome to give your input as well. But Chris, can you speak to the use of unaccepted offers to license within a reasonable royalty analysis?
You said unaccepted offers?
Yes, unaccepted offers to license.
Yeah, understood. So, it's an interesting topic, and I'll assume that the listener is referring to an earlier offer to license by the plaintiff or the patentee. And so qualitatively, I would identify the concept that, or I would double back to the concept that Cleve had referenced earlier about the willing licensor licensee construct. This is assumed within the hypothetical negotiation construct, but experts will often consider earlier offers to license in their evaluation of Georgia Pacific 4, which really relates to the plaintiff's established licensing policy. Again, that's a sort of a qualitative issue. Quantitatively, I would say that such offers are typically treated with significant caution. A critical difference really lies between whether an offer is being considered by the parties ensued at the hypothetical, or is it the ultimate outcome of the hypothetical negotiation. Notably, just a few days ago, I think it was within the last couple of weeks, there was a case in New Mexico where the district court, it was applied capital and ADT, I believe. The court ruled that a rejected offer could serve as the starting point for the negotiation. But it did indeed, it appeared from the language of the court that a critical point there was it being advanced as a starting point, or was it advanced as an end result? But I would say proceed with caution with unaccepted offers.
Thank you so much for that, Chris. And Cleve, a question for yourself just to round things out. But Chris, you're more than welcome to give your input as well. But Cleve, how do you approach a situation where there are multiple estimates for the value of a patented technology? How do you narrow that down to a reasonable royalty?
Yeah, that's a pretty common issue to arise, and I think that an expert wants to address value from multiple perspectives and then hone in on a reasonable royalty. Some approaches can lead to a series of ranges. Sometimes what we'll do there is we'll take these ranges and align them with, we call this a tornado graph. We actually align the one with the biggest range at the top, and then if there's 4 or 5 of them, the narrow ones at the bottom. And if you look at it, it kind of looks like a tornado. And what you're looking for is sort of a common rate that would kind of apply to all of those. But I think as an expert, you shouldn't necessarily feel compelled to provide necessarily just one number is a reasonable royalty. Sometimes you would want to provide a range. After all, an expert's there to assist the fact finder in adopting a reasonable royalty in a case, and that can be quite helpful for them. And actually, I think it can actually indirectly help with the integrity of an expert to show, look, there's uncertainty here. Here's what we know is going to be in this range, which I think, sometimes an expert that comes in with a specific estimate, down to the penny, implies a precision that's not there with these sorts of analyses. But you would want to use, the multiple approaches. Some are better than others. You'd want to understand that, obviously, and then hone in, but take into account all of them in doing so.